When something goes wrong in a contract, the first question a lawyer asks isn't, was there a breach? It's, what kind of term was broken? Because the type of term determines the remedy, and the remedy is everything. A contract is built from terms. Some you can see in the written document, some the law reads in for you, and some whose legal weight only becomes clear when a court classifies them. This lesson maps out each part of that picture. Express terms are the ones the parties have actually agreed, whether spoken aloud or written down. The starting point is that a written contract is taken to contain the complete agreement. That's the parole evidence rule, which prevents a party from using external oral statements to add to or contradict a written contract, though it has limits in practice. For a term to be incorporated, it must be part of the contract at the moment it was formed. A notice or document handed over after the contract is made is too late, as in Ollie Volriv Marlborough Court 1949, where exclusion terms on a hotel bedroom wall were not incorporated because the contract had already been formed at the reception desk. Where terms are contained in a signed document, signature is generally conclusive. Lestrange v. Gracob 1934. Where terms appear in an unsigned document, the party relying on them must show the other had reasonable notice. Not every term appears in the contract, some are implied into it. Terms can be implied by statute. For example, the Sale of Goods Act 1979 implies terms about satisfactory quality and fitness for purpose into contracts for the sale of goods, and the Consumer Rights Act 2015 does the same in consumer contracts. Terms can also be implied by the courts, in fact, meaning the court reads in a term to fill a gap in a specific contract. The two classic tests come from the Moorcock, 1889, business efficacy, meaning the term is necessary to make the contract work, and the officious bystander test from Sherlaw v. Southern Foundries, 1939, asking whether both parties would obviously have agreed to the term without hesitation. More recently, in Marks and Spencer v. BNP Paribas, 2015, the Supreme Court confirmed that business efficacy and the officious bystander tests remain the correct approach, and that a term will not be implied merely because it would be reasonable. It must be necessary. Finally, terms can be implied by law into recognized categories of contract, such as the duty of care in employment contracts. Once you know a term exists, the next question is how important it is. And here the traditional classification begins. A condition is a term that goes to the root of the contract. If it is breached, the innocent party has a choice. They can treat the contract as terminated and claim damages, or affirm the contract and claim damages alone. The leading illustration is Poussard v. Spears and Pond, 1876. An opera singer failed to appear for the opening night of a run, not just a rehearsal, but the very performance the contract was for. The court held that her obligation to perform from the first night was a condition, so the theatre was entitled to engage a replacement and treat the contract as discharged. Courts look at the substance of the term, not just the label parties apply. Calling something a condition in the contract does not automatically make it one in law, as the court will examine what the parties objectively intended. A warranty is a term of lesser importance, one that is not central to the main purpose of the contract. Breach of a warranty entitles the innocent party to damages, but not to terminate the contract. The contrast with conditions is sharply illustrated by Bettini v. Guy, 1876, decided in the same era as Poussard. There, a singer failed to attend several rehearsals before a season of performances, but did appear to perform the actual engagements. The court held that the rehearsal obligation was a warranty, not a condition. It was subsidiary to the main purpose. Crucially, the innocent party could not walk away from the contract. They were limited to a damages claim for any loss caused by the missed rehearsals. As with conditions, labels in the contract are a starting point, but not conclusive. The binary condition warranty split proved too rigid to handle the variety of real contractual obligations, and in Hong Kong, Fur Shipping Co. v. Kawasaki Kisen Kaisha, 1962, the Court of Appeal recognized a third category, the innominate or intermediate term. The facts involved a charter party in which the ship was warranted as seaworthy. The The vessel turned out to have an incompetent engine room crew and required extensive repairs, keeping her out of service for around 5 months. The charterers purported to terminate. The Court of Appeal held that seaworthy was neither a condition nor a warranty. It was an innominate term, capable of being breached in many ways, some trivial, some catastrophic. The remedy depends not on the classification of the term itself, but on the consequences of the particular breach. Termination is only available if the breach goes to the root of the contract. That is, if it deprives the innocent party of substantially the whole benefit they were intended to receive. Because the charterers still received substantial benefit from the contract despite the delays, they could not terminate. They were limited to damages. The innominate term category gives courts flexibility, but at the cost of some certainty at the time of contracting. An exclusion clause is a term by which one party seeks to exclude or limit their liability for breach or for certain types of loss. Before any question of legal validity arises, the clause must first clear the incorporation hurdle. It must have been part of the contract at formation, whether through signature, reasonable notice, or a consistent course of dealing. Even if incorporated, the clause must, on its true construction, actually cover the breach in question. Courts read exclusion clauses strictly, and any ambiguity is resolved against the party relying on the clause, under the contra proferentem principle. Once those common law hurdles are passed, statute takes over. The unfair contract terms. Act 1977 governs business-to-business contracts. It renders void any attempt to exclude liability for death or personal injury caused by negligence and subjects exclusions of other loss to a reasonableness test, assessed at the time the contract was made. In consumer contracts, the Consumer Rights Act 2015 applies instead. It too renders void exclusions of liability for death or personal injury caused by negligence and requires other terms, including exclusion clauses, to be fair and transparent. An unfair term in a consumer contract is not binding on the consumer. Here's your check. A charter party describes a ship as seaworthy. On delivery, the ship has minor surface rust that has no effect on the voyage whatsoever. The charterer tries to terminate the contract, citing breach of the seaworthiness term. What is the likely outcome? Option A, termination allowed. Seaworthy is a condition. Option B, termination allowed. Any breach of an express term justifies termination. Option C, termination refused. The consequences of the breach are not serious enough. Option D, termination refused. Seaworthy is always a warranty. The answer is C. Following Hong Kong Fur, seaworthiness is an innominate term, and termination is only available where the breach deprives the innocent party of substantially the whole benefit they were intended to receive. Minor rust with no effect on the voyage falls far short of that threshold. Every contract term is either express or implied, and its classification as a condition, warranty, or innominate term combined with the rules on exclusion clauses determines exactly what remedy a breach will unlock. Your modules, mapped to your uni, explainer videos for every topic, a tutor that knows your course, essay writer for your essays and graded, case briefs, flashcards, annotations. Try it free for 7 days, link in the description.